Good day, Crime Talk aficionados. We have a great show for you today. First, jurors in the Karen Reed case say they are a hung jury. The judge says go deliberate some more. And then they say, we're still hung, and the judge agrees. Let's talk presidential immunity. The Deadpool Killer gets the death penalty. Alec Baldwin's motions are denied. Trial will begin in a week or so. Sarah Boone is the problem, the judge determines. Another Mother of the Year contestant. Sean Combs gets fired by his law firm, and an Ohio judge admits he made a mistake. That's not the story. That's not the big story. The fact is that he was big enough to admit it and grant a new trial. And finally, our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below, and make sure you hit that little bell so you get notifications of when we go live or put up new content. All right. Can you believe that it is already July 1st, 2024? I cannot believe the year is half over already. Anyway, we are back from our little excursion to Hawaii. Good to be back in the studio. So let's get to today's program. First, jurors in the Karen Reed trial said that they can't come to an agreement over whether the ex-college professor murdered her cop boyfriend. The juror, made up of 6 men and 6 women, wrote a note Monday morning on the 5th day of deliberations telling the judge they haven't been able to reach a unanimous verdict. The note read, "We find ourselves divided by fundamental differences in our opinions. The divergence in our views is not rooted in lack of understanding, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable." The judge told them to go back after they also told the judge on Friday that they were a hung jury. And then about 2:30 Eastern time, we brought it to you live here. The jury came out yet again and said, we are at an impasse. We are not going to compromise on these deeply held convictions. Some jurors believe the prosecution has met their burden. Others believe that the prosecution has failed to meet their burden. And needless to say, we're not going to make a decision. The judge agreed, declared a mistrial, and set the matter for a status hearing on June 22nd. Should have happened last Friday, but hey, judge, no one ever listens to Scott. I get it. I don't know what the heck I'm talking about. Anyway, next on the docket, anything come out of Supreme Court lately? Any big news out of there? Yeah, there were lots of big cases last week, and we'll talk about some of them a little bit more in the future. But today, hey, let's talk presidential immunity. Now, I don't think everyone needs to panic that the president's going to go out and start killing people. This just states what everybody knew. It was just that no one had ever tried prosecuting a former president until now, and therefore nobody needed rules of clarification. So, for example, George Bush starts a war, lies to people to get a war, or let's say President Obama kills U.S. citizens with drones overseas. He could have been charged with murder. But guess what? People said he can't do that. He's the president. He can make those types of calls. Like I said, no one had ever tried prosecuting a president for what they did in office. And I think what the rules that the Supreme Court laid out are quite clear. If it's an official act, you are going to have immunity because we need the president to be bold to make decisions. If it's clearly an illegal order, go kill my opponents, that's an illegal order, and someone isn't going to follow with that. And nothing should, in fact, take place, so to speak. Nothing's going to go prosecute that. That's the big draconian thing. Oh, my gosh. What if Biden were to go, say, kill my opponents or go prosecute them to the fullest extent of the law? Well, isn't that illegal? Doesn't matter. I have immunity, right? But if, let's say, for example, I don't know, a dead hooker winds up on the bathroom door in the White House, not an official act. You understand what I'm saying? Hopefully we'll try to clarify that a little bit more. But a divided Supreme Court Monday ruled that the former president can never be prosecuted for actions relating to the core power of their office, and that there is at least a presumption that they have immunity for their official acts more broadly. Now, the decision left open the possibility that the charges brought against former President Donald Trump by special counsel Jack Smith, alleging that former President Trump conspired to overturn the results of the 2020 election, can still go forward to the extent that the charges are based on his private conduct rather than his official acts. The case now returns to the lower courts for them to determine whether the conduct at the center of the charges against former President Trump was an official act or an unofficial act, an inquiry that, even if it leads to the conclusion that the charges can proceed, will almost certainly further delay any trial in the case, which had originally been scheduled to begin on March 4th of this year, but is currently on hold. Now, writing for the majority, Chief Justice John Roberts emphasized that the president is not above the law. But Justice Sonia Sotomayor, in a dissent joined by Justices Elena Kagan and Ketanji Brown Jackson, countered that if a future president misuses official power for presidential gain, the criminal law that the rest of us must abide will not provide a backstop. Now, the decision was the latest chapter in the case that began last year when Donald Trump was indicted on 4 counts arising from special counsel Smith's investigation into the January 6, 2021 attacks on the United States Capitol. Now, the indictment alleges that President Trump created widespread mistrust through pervasive and destabilizing lies about election fraud, and then conspired to undermine a bedrock function of the United States federal government, the nation's process of collecting, counting, and certifying the results of the presidential election. Well, President Trump asked the trial court judge to throw out the charges against him, arguing that he is immune from prosecution because he was the president. Now, the district court judge turned that request down back in early December, explaining that the presidency does not confer a lifelong get-out-of-jail-free pass. Well, special counsel Smith went to the Supreme Court later that month asking the justices to weigh in on Trump's immunity without waiting for the United States Court of Appeals for the District of Columbia Circuit to rule on Trump's appeal. But the justices declined to do so, and it was 6 weeks before the Court of Appeals issued the opinion rejecting Trump's claim to immunity. Well, then President Trump then came to the United States Supreme Court seeking review of the D.C. Circuit's ruling. 2 weeks later, the justices agreed to take up the case. They scheduled the argument for late April, putting the case on a fast track that normally would have been but a slower schedule than they had established for other cases involving the former president. Now, the challenge to the Colorado disqualification of the former president from its ballot for his role in the January 6 attacks, remember that case? That case was set for argument just over 1 month after the court announced that it would review the case in January, and the court issued its decision for Trump just under 1 month after the oral arguments. Now, there was some requirement for that because they had to have it out so they could make a decision as to whether he was going to be on the ballot here in the state of Colorado. Obviously, the unanimous Supreme Court said the Colorado Supreme Court got it 100% wrong. Anyway, in a ruling on the last day before the Supreme Court's summer recess and just over 2 months after the oral arguments, a majority of the court rejected the D.C. Circuit's reasoning. As an additional matter, Roberts explained in a 43-page ruling, presidents have absolute immunity for their official acts when those acts relate to the core powers granted to them by the Constitution. For example, the power to issue pardons, veto legislation, recognize ambassadors, and make appointments. The absolute immunity does not extend to the president's other official acts. However, in those cases, Robert reasoned a president cannot be charged unless, at a very least, prosecutors can show that bringing such charges would not threaten the power and functioning of the executive branch, and there is no immunity for a president's unofficial acts. Now, determining which acts are official and which are unofficial can be difficult, the Chief Justice acknowledged that. He emphasized that the immunity that the court recognizes in its ruling on Monday's decision takes a broad view of what constitutes president's official responsibility, covering actions so long as they are not manifestly or palpably beyond his authority. In conducting the official-unofficial inquiry, the Chief Justice added, courts cannot consider the president's motive, nor can they designate an unofficial act simply because it allegedly violates the law. Turning on some of the specific allegations against the former president, the majority ruled that Trump cannot be prosecuted for his alleged effort to leverage the Justice Department's power and authority to convince certain states to replace their legitimate electors with Trump's fraudulent slate of electors. With regard to the allegation that Trump attempted to pressure his former vice president, Mike Pence, in his role as president of the Senate to reject the state's electoral votes or send them back to state legislators, the court deems Trump presumptively immune from prosecution on the theory that the president and the vice president are acting officially when they're discussing their official responsibilities. On the other hand, Robert observed the vice president's role as president of the Senate is not an executive branch role. The court therefore left it for the district court to decide whether prosecuting Trump for this conduct would intrude on the power of the operation of the executive branch. Now, the court did the same for the allegations in the indictment regarding Trump's interactions with private individuals and state officials, allegedly attempting to convince them to change electoral votes in his favor, as well as Trump's tweets leading up to January 6th. Now, that includes the tweets, the alleged attacks, and the speech at the Ellipse that day on January 6th. Making this determination, the Chief Justice wrote, will require a close analysis of the indictment's extensive interrelated allegations. So, the Chief Justice pushed back against the dissent by Sotomayor and a separate one by Justice Ketanji Brown Jackson, describing them as striking a chilling tone of doom that is wholly disproportionate to what the court actually does in this ruling. He portrayed the ruling as a relative narrow one that decides only that immunity extends to official discussions between the president and his attorney general, and then remand the lower courts for them to determine whether the other acts alleged in the indictments are entitled to immunity. In her dissent, which, like Justice Jackson wrote, notably did not use the traditional respectfully, Sotomayor contended that Monday's ruling reshapes the institution of the presidency. Whether described as a presumptive or absolute, she wrote, under the majority rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. That is just as bad as it sounds, and it is baseless. With fear for our democracy, she concluded, I dissent. Like I said, ladies and gentlemen, this is really the rule that everybody's always known about, but they've never had to do it because nobody's ever had the chutzpah to basically try and prosecute a former president for actions that took place while he was still president. People just didn't do it because they knew that he was acting within his official capacity. Even if he got it wrong, he was relying upon advisors. He was doing what he thought was appropriate at the time. So whether you like it or not, like I said, the people that went after the president, they're the ones that have now created this precedent where it's saying, hey, let's talk official, unofficial. Be careful what you wish for sometimes, ladies and gentlemen, because you just may get it. Anyway, I don't think it's the doomsday scenario that everyone envisioned. And guess what? You still have to win at the ballot box. And if people think that you're acting above the law or you're not subject to the law, guess what? The remedy is to vote them out. Oh, but that's right. We're supposed to do that with members of the House and Senate, but we don't do that either because incumbents have a very high traditional rate of people voting for them again because of the psychological effect that basically people don't like to admit that they made a mistake. And therefore, that's why we get the same people back in office over and over and over again who basically ignore the will of the people, remain there for life. Anyway, that's subject for a different day. Next on the docket, the Deadpool murderer gets sentenced to death. That's right, Wade Wilson. Now, this guy made some headlines back in 2019 after he slaughtered 2 women within a matter of hours, with images of his striking tattoos appeared circulating across the internet. Now, he's been dubbed the Deadpool Killer as he shares the name with the Marvel character. Now, Wilson was convicted over the murder of Christine Melton and Diana Ruiz, who the prosecutors say he killed simply for the sake of killing. Now, video of Wilson's eerie hand signal sparked speculation online, with some morbid female fans also appearing to swoon over the killer's heavenly tattooed look. Now, he began on the afternoon of October 6th of 2019 when he met Melton at a live music bar and went home with her. Wilson strangled her to death inside her home in Cape Coral, Florida, the next day, where her body was found inside the apartment. The same day, Ruiz was reported missing after she was seen being asked for directions by Wilson while on her way to work. He was driving a car he stole from Melton's home after he murdered her, which Ruiz got into before she was also strangled to death. Now, in testimony from Wilson's father, it was said that he went on to run her over until she looked like spaghetti. Now, Ruiz's body was found 3 days later in a field behind a Sam's Club. Now, the 30-year-old killer also drove to Fort Myer in Melton's car and attacked a woman by the name of Miss Montez, his ex-girlfriend. Now, Wilson was arrested on October 8th, where he remained behind bars without bail until he was found guilty of murder this past month. Now, Wilson added a number of tattoos since he was arrested, and his face includes several swastikas, including a menacing Joker-like mouth tattoo and a neck tattoo reading "Bread for War." While the jurors voted to send him to death row, with Mr. Wilson in the courtroom appearing emotionless and as he learned his fate. I say good riddance. You can't go around killing people just to kill people. Good riddance. Next on the docket, Alec Baldwin. His motions were denied. I think I said they would all be denied. And let's find out why the judge denied the motions. Oh, for the exact same reason I said they would be. So the judge handling the Alec Baldwin case Friday afternoon rejected Alec Baldwin's latest attempt to dismiss his involuntary manslaughter case, allowing the actor's trial over the fatal shooting of a Rust cinematographer to proceed in less than 2 weeks. Now, Baldwin's attorneys had asked the judge to throw out the case after the firearm that killed the cinematographer, Helena Hutchins, on the Rust movie set back in 2021 was damaged during forensic testing at the FBI lab. But in a written ruling, the judge said, among other reasons for denying the motion based upon the arguments that Mr. Baldwin and his team offered, no evidence beyond speculation and conjecture that the unaltered gun could have exonerated him. Now, evidence of a modification does not render an unaltered firearm potentially useful evidence without explanation as to how additional testing with the modification present might have exonerated the defendant. Now, the judge concluded that the gun did not meet the relatively low standard of potentially useful evidence, and that she did not find the state acted in bad faith in altering the firearms. However, the judge did rule that the prosecution must fully disclose the destructive nature of the firearm testing, the resulting loss, and its relevance and importance to the jury. Well, okay, those can come out on cross-examination, and I'm sure the defense would have brought that out on cross-examination as well. So now the prosecution gets to do it and steal some of the thunder from the defense. Well, with this ruling, guess what? We are going to trial, and the trial is set to begin in just a week and a half, I believe July 8th for his trial setting. Now, if Mr. Baldwin is convicted, he faces up to 18 months in prison. Now, remember, he's pled not guilty, so he's entitled to that presumption of innocence. But the armorer, Yes, the armorer was convicted of nearly identical charges, and guess what? Got 18 months in prison. So one could reasonably conclude that the person who actually pulled the trigger, that's right, pulled the trigger, would get 18 months in prison as well. We will bring you that trial next week when jury selection begins, ladies and gentlemen, right here on Crime Talk. Next, Sarah Boone is the problem. Ooh, once again, what did Scott say last week? She doesn't get any more attorneys. Well, guess what? The judge has concluded what I said should have happened, that Miss Boone has forfeited her right to have an attorney, meaning she will have to represent herself at her upcoming trial. Now, as you may recall, Miss Sarah Boone is charged with second-degree murder and faces a potential sentence of life in prison if she's found guilty of killing her boyfriend, Jorge Torres, who was found zipped inside a suitcase back in February of 2020. Now, Ms. Boone has admitted to zipping Torres into the bag, but has maintained that the death was an accident and the result of a game of hide-and-seek simply gone wrong. Now, Ms. Boone's case has been pending for more than 4 years because she has gone through a string of court-appointed attorneys, each of whom has withdrawn from her case, citing irreconcilable differences. Anyway, on Friday, the judge issued a ruling in response to Boone's 8th attorney asking to withdraw from the case. The judge granted the request and noted that Boone has, through her conduct, waived her right to court-appointed counsel. Now, the judge noted that each of the previous attorneys on Boone's case had similar complaints. Mr. Padilla, who represented Boone for more than 2 years from 2020 through 2022, said he could not offer many details of the irreconcilable differences, noting he was under a belief that the specifics of the adversarial relationship, if they're disclosed, may prejudice his client and as such will stand mute on the specifics. Then you had Mr. Bankowitz, who represented Ms. Boone from July of 2022 through September of 2023, said that Boone would call him 5 to 10 times per day and reported that she would refer to him as a dud and a buffoon. Now, when Mr. Padilla withdrew from the case back in May of 2022, the court advised Ms. Boone that this state's concern regarding a strategy of defendant being unhappy with every attorney and advised the defendant about the dangers of self-representation. Similarly, Boone was warned again when Mr. Bankowitz withdrew from his case, with Bankowitz noting in his own motion, the defendant will not be satisfied with any attorney unless said attorney does not have a case load and can dedicate his or her time solely to Ms. Boone's case. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. Now, I can tell you as a practicing attorney, every now and then you get one of those clients. No matter what you do, it's never going to be good enough. And the only thing you can do is run as quickly as possible, ladies and gentlemen. Anyway, it went on for Ms. Boone. Mr. Hobson was appointed to replace Mr. Berkowitz. He withdrew in February of 2024. The court advised the defendant that although the defendant has a right to court-appointed counsel, that right is not unlimited, and the court twice advised Ms. Boone that the defendant may not be provided another court-appointed attorney, and that defendant would have to represent herself if circumstances similar to Mr. Hobson's motion to withdraw occur again. The court once again advised Ms. Boone about the dangers of self-representation due to the defendant's lack of legal training and knowledge. Oh, come on, how tough could it possibly be? Just Google it, right? How tough is it? It was just a little accident, a little trick gone bad. How tough could that be? Anyway, the judge noted once again that Boone's most recent and final attorney, Patricia Cashman, has extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able to and be willing to deal with and manage difficult clients. That's right, a client whisperer. Nonetheless, in a 58-page letter submitted to the court, Ms. Boone complained that Ms. Cashman was impossible to work with and had an unwarranted, uninformative, unprofessional, snotty attitude. Well, guess what? Now Ms. Boone gets to do it herself, and the judge said we're going to start trial on October 7th, and anything short of some extraordinary good cause, that's the only way this case will not go to trial. I say, Ms. Boone, you have earned yourself the right to represent yourself. You couldn't get along with 8 attorneys. The problem is not the attorneys, Ms. Boone. It is you. So you're going to go to court by yourself. You're going to make a complete fool of yourself, probably completely screw up your record. The good thing is that by your 8th attorney, you've completely waived it, and you waive your right to any ineffective assistance claims down the road. So we're going to have one trial and one trial alone. And of course, the first thing on appeal will be, I didn't want to represent myself. I begged for an attorney. Mark my words, is what Ms. Boone will be saying here shortly, that she is inexperienced with these big courtroom ways, inexperienced with these laws and the rules of evidence, and just can't be held to the same standard as a practicing attorney. That's the standard she will be held to as a pro se defendant. But that's all right. That is all right. She will just have to do it herself and bear the consequences. Next, another Mother of the Year contestant, and not in a good way. Now, 2 women charged in what the Columbus Police Department say is a homicide of an 8-year-old reported missing last Friday in the Milo Grogan neighborhood, turned themselves in Saturday evening, according to the police. Now, LaShonda Wilder of Near East Side, Ohio, faces murder and obstruction charges, and Jana Sloma Marie Lowe of the North Side, an obstruction charge in Franklin County Municipal Court in the death of Wilder's son, Martonio. Now, police say they found what they believe is the 8-year-old body Friday afternoon in the family's home. Now, the police chief said at a news conference late Friday night that police did not know how Martonio Wilder died and would await the results of the autopsy by the coroner. But they're saying the death is suspicious. Late Saturday afternoon, police said the coroner ruled Martonio's death a homicide and that they charged Wilder with murder. The court documents also indicate the coroner found deep neck compressions on the victim. Now, a short time later, about 5 p.m., both women turned themselves into the Columbus Police Department and were booked into the county jail. Now, the police chief said Wilder called police just after noon on Friday to report that Martonio had been missing since around 9:30 p.m. on Thursday. She said her son previously wandered off in the neighborhood, and she told police that she was last seen around Olmsted and St. Clair Avenues near the house. Anyway, the police responded to the Wilder home and deployed drones and helicopters to search for the area of the missing boy. But guess what? When police brought a canine cadaver dog to search the home, Miss Wilder became uncooperative and did not want canine dog inside the house. Gee, I wonder why. That's right, because that's where the little boy's body was. Now, while the dog was searching the house, Miss Wilder, Lowe, and Wilder's 2 other children left and went to the Lowe's down the street. The detectives allege in court documents, and while Wilder and Lowe left the children there with Lowe's mother, and then each left separately. Police and relatives tried unsuccessfully to reach Wilder and determined her phone had been turned off. Now, police issued a missing persons release for Martonio on Friday afternoon, and due to his age, the missing person unit classified him as endangered missing. Detectives got a search warrant for the Wilder home, where they found Martonio's body hidden inside a plastic trash bag inside a bivvy cover in the attic on Friday afternoon. An Amber Alert for the other 2 boys was issued at 9:07 p.m. on Friday as in a child abduction, saying they were possibly with their mother by 9:30. However, the alert had been canceled. And next, old Sean P. Diddy Combs fired by his attorneys. Now, the Manhattan law firm of Grubman, Shire, Marcellus, and Sachs, which represents apparently a lot of heavy hitters in the music industry, has kicked rapper Sean Diddy Combs to the curb. Now, the decision is why that came about, why the firm decided to part ways with Mr. Combs was proactively made by the partners in the firm a number of months ago, and they felt that it was just the right thing to do. But there's other allegations that another heavy hitter client of the firm, Lady Gaga, told the firm to either drop Mr. Combs, who is facing mounting sexual assault allegations, or she would walk away from the firm. So I'm sure the clients did not dictate that, but they suggested it, and then the firm said, we're going to make a financial decision here. Now, I got a real problem with this if that's the case. Listen, if you are a boutique firm and that's what you do, you represent boutique, bougie type people, right? And you don't want to have somebody like Mr. Combs getting in trouble. Well, that's what lawyers are supposed to do, represent people throughout their problems. And if you're going to ditch them just because they get in a little bit of trouble, I get it. Or maybe that's not your area of expertise, then get them the representation they need. But to have other clients saying we're going to ditch you if you continue to represent this particular client, not cool at all. Anyway, like I said, the firm says that it wasn't client pressure. That's just simply not true. So anyway, P. Diddy, you got a lot of trouble. You know, we're probably not going to hang out together, but we would take you on as a client. Don't get me wrong. You're going to need some serious representation. We could help you out. Just saying. Now, it's not a solicitation for representation. I'm just saying, Mr. Diddy, we will take your money. All right. Next, an Ohio judge admits that he got it wrong, which is shocking in and of itself. But the fact that he actually says, I'm going to give a new trial because I got it so wrong, crazy. Never happens. Okay. Trial court judges make decisions and they move on. If they are told that they messed up, the appellate courts will tell them to do so. And most trial court judges will say, I've made a decision. If I'm wrong, the appellate courts will tell me so. But a judge in Ohio has basically said, yeah, I screwed up. So after 15 years on the bench, the Franklin County Common Pleas Court judge said that this is one of his firsts. The judge, Mark Surratt, granted a new trial for a man who had been found guilty of murder by a jury in May. Now, Mr. Leroy Robinson had been scheduled to be sentenced on December 2nd for the death of Malik Islam. Now, the judge, in his 14-and-a-half-year tenure as a judge in hundreds of jury trials, has never overturned a jury verdict. The judge wrote, this is a rare exception where the justice requires a new trial. So on May 31st, a jury found Robinson not guilty of purposely killing Islam, but found Robinson guilty of killing Islam during a felonious assault, discharging a firearm near prohibited premises, and felonious assault. Now, evidence presented at Robinson's trial showed that around 12:10 a.m. on December 2nd, Robinson was sitting in a parked car on the city's northeast side. Islam approached Robinson and was verbally aggressive towards Mr. Robinson. After a second verbal confrontation, Robinson testified that he saw Islam reaching into the pocket of something that he thought was a gun. Robinson fired a single shot, which struck Islam, and he drove away from the scene. Now, Robinson had argued at trial that he shot Islam in self-defense and that Islam had a reputation for being violent and dangerous, which multiple witnesses testified to during the trial. Now, during the jury's verdict, Robinson's attorney filed a motion to dismiss the case or for Surratt to set aside the verdict and grant Robinson a new trial. The attorney's main argument surrounded an instruction given to the jury before it began its deliberation about whether Robinson was required to retreat before using deadly force. Prosecutors had argued that the verdict should stand and that any issues with the case should be brought up on appeal to see if there was any error made. Anyway, the judge determined in his ruling that the instruction he gave the jury was the exact opposite of what the law requires. The judge said the instruction likely misled the jury And in a footnote, at least 4 jurors had asked Surratt if Ohio had a stand your ground law. These jurors indicated they would never have voted guilty had they known the defendant had no duty to escape or retreat. One jury was visibly upset and had repeatedly contacted the court regarding changing his verdict. The judge noted in his decision that giving someone a new trial before they are sentenced and an appeal court review of the case an extreme remedy, but felt that the correct thing to do under the circumstances. The judge found the jury's verdict was contrary to law because the evidence did not clearly disprove Robinson's assertion that he had acted in self-defense when he shot Islam. The erroneous jury instruction only further contributed to and compounded the injustice, the judge wrote. Robinson's case has been set for a hearing on July 8th, and a new trial date has not yet been set. So there you go, ladies and gentlemen. Judges usually don't admit they're wrong. They just don't do it. So for this judge to actually do it, to say, realized I made a mistake, but this is where the judges are supposed to be the one responsible for giving the correct instructions of the law. Happens all the time. Most cases they come back, the judges mess up the instructions. At least this judge had the guts to do it early. Next, our dumb criminal of the day. Check out the video posted on social media that saw this guy attempting to get inside the lobby of a Marriott hotel by him punching the glass door, shattering one of the panes quite instantly. To break his way inside, he then continues to repeatedly kick the glass door, almost knocking it from its hinges. Then he soon regretted that decision when the police arrived. As you can see, footage shows the man first standing at the door, breaking his way inside, but once he reaches the front desk, appears to act as if nothing had happened. It's not long before the maintenance workers, security, and police are on the scene, and the man fails to comply with the instructions given by the police. Things get a little tense. The officer pulls out a pair of handcuffs while the man is standing at the hotel reception desk. And towering over the police officer, he could be heard protesting, saying, "I'm a citizen." The man refused to offer his hands to be placed in cuffs, but then appeared to have heard enough. Catching the man off guard, he abruptly punches the man in the jaw, knocking him off balance. The officer is then able to wrestle the man to the ground, placing the knee in the back of the man's head while grabbing his wrists in order to firmly place them in handcuffs and arresting the guy. Thing of the day, just open the dumb door. Don't kick your way into it, ladies and gentlemen. If you do, say, "Oh, I really apologize. I can't believe that thing broke." Anyway, here we go again. All right. Thanks for watching. We'll see you next time on Crime Talk. And remember, the Constitution matters.